Good morning. This is Rajeshkumar. Today we are going to analyze one problem question on frustration. The video content has been made available for informational and educational purpose only. Kindly go through this slide completely. Let's start with the problem question. In January 2023, Carl booked a holiday at Adventure Camp in May 2023 for £3,000. Adventure Camp is a venue which specializes in extreme sports, offering a variety of activities, including cliff diving. Carl paid £1,000 deposit in January, with the remaining £2,000 to be paid in two installments. £1,000 on 1st March and the £1,000 upon arrival. On 5th March, Carl discovered that cliff diving is no longer an available activity, and so he calls to cancel the holiday. Adventure Camp tell Carl that all other activities are still available and that they will keep his place open and they expect the full payment. Carl is very upset but decides he will still go on the holiday. 2 days before the Carl's holiday is due to start, Adventure Camp is closed down by health inspectors due to an outbreak of food poisoning. It is later discovered that the outbreak was caused by contaminated milk used in the manufacturing process of the ice cream that is sold at Adventure Camp. We have to advise Carl. And the alternative scenario is how, if at all, would your answer differ if the food poisoning was caused by Adventure Camp chef storing the butter uncovered on the same plate as raw meat? Call's case primarily raises issues related to the doctrine of frustration, which allows a contract to be discharged when unforeseen events, through no fault of either party, make the performance impossible or radically different from what was originally agreed. If the frustration is not established, Call's decision to cancel could potentially be treated as an anticipatory breach. The key case laws such as Davies Contractors and Farham UDC and Hearn-based Steamship Co. versus Houghton in 1903 provides the foundational principles for determining whether a contract has been frustrated. Additionally, the law reform Frustrated Contract Act 1943 will be relevant in addressing the consequences of frustration, particularly with respect to calls payment. Let's start with the first issue, the unavailability of cliff diving. That's Call's initial attempt to cancel the contract. The Call's first reaction to the unavailability of cliff diving suggests an intent to cancel. This element alone does not fulfill the criteria of frustration under the contract law. The frustration occurs only when an unforeseeable external event fundamentally changes the contract purpose or makes the performance impossible, as established in Davis Contractors Limited versus Fareham Urban District Council in 1956. Here, only one activity among the several was no longer available, meaning that the camp experience was not radically altered, which limits the applicability of frustration. Call's attempt to cancel could therefore be considered an anticipatory breach since he tried to withdraw from the contract based on the partial change. In White and Carter Councils Limited versus McGrath in 1962, the court held that when one party attempts anticipatory breach, the other party can refuse the breach and demand continued performance, which Adventure Camp did. In other words, on 5th March, Call attempted to cancel his booking upon discovering that the cliff diving, one of the activities at the adventure camp, was no longer available. However, Hearn based Steamship Co. versus Houghton in 1903 demonstrates that the frustration only occurs when the primary purpose of the contract is defeated. Since other activities at the adventure camp remains available, this would not constitute frustration. As a result, the call's attempt to cancel could be seen as an anticipatory breach under the White and Carter Councils Limited versus McGrath in 1962. It's allowing the adventure camp to insist on the contract's continuation and payment. Let's move on to the second issue, the closer due to the food poisoning outbreak. It's a frustration due to impossibility. Just 2 days before the call's holiday, the adventure camp is shut down due to the health hazard, which directly impacts the contract. This type of event could meet the frustration doctrine criteria as it entirely prevents the provision of the holiday services a call contracted for. Under Hearn Bay Steamship Co. versus Houghton in 1903, if an essential element like the venue's availability becomes unavailable, the contract can be frustrated. Moreover, the Super Servant 2, 1990, establishes that if the performance of the contract is rendered impossible by unforeseen circumstances beyond either party's control, the frustration may discharge the contract automatically. Since the camp closure is a public health issue and not Adventure Camp's fault, the call's contract may be considered frustrated. The Law Reform Frustrated Contracts Act 1943 would govern the outcomes, likely allowing call to reclaim any prepayments minus the reasonable expenses incurred by the adventure camp before the frustration occurred. In other words, just 2 days before the call's holiday, the adventure camp was closed by the health inspector due to an outbreak of food poisoning. This closure renders the performance of the contract impossible as call cannot attend the holiday at all. The scenario fits into the category of frustration by impossibility, as established in Taylor versus Caldwell in 1863, where the destruction of a music hall frustrated a contract for its use. Here, the adventure camp closure makes the holiday impossible, thus discharging the contract. The principle was also applied in Gamaco SA versus ICM Fair Warning in 1995, where a concert contract was frustrated due to the venue being declared unsafe. So, what are the consequences under the Law Reform Frustration Contract Act 1943? Under Section 1(2) of the Act, Call would be entitled to recover £1,000 deposit he had paid. Further, since the frustrating event occurred before the balance of £1,000 due upon arrival was paid, he is no longer obliged to make the payment. However, Adventure Camp may seek to retain or recover the part of the deposit to cover any expenses incurred prior to the frustrating event. Let's move on to the final scenario, is alternate situation where the self-induced frustration scenario, a butter incident. If the food poisoning was caused by negligence, such as improper food handling by adventure camp chef, the frustration would not apply since the event would be self-induced. The principle from Maritime National Fish Limited versus Ocean Travels Limited in 1935 supports that frustration cannot be claimed if the event is within the control of one party. The adventure camp negligence would make them liable for breach, and call would be entitled to damages for non pecuniary loss, compensating him for his distress and loss of enjoyment due to unavailability of the holiday. In other words, if the food poisoning was caused by adventure camp chef storing the butter with the raw meat, this raises the issue of self induced frustration. The doctrine of frustration does not apply when the frustrating event is the fault of the one of the parties, as seen in Maritime National Fish Limited versus Ocean Travels in 1935 and the Super Servant 2 in 1990. If the adventure camp's negligence caused the closure, the contract was not be frustrated. The adventure camp would be in breach. What is the consequences of this self-induced frustration? If the frustration is deemed self-induced, the call could claim damages for the breach of contract, including the compensation for the lost holiday and any related expenses. He may also be able to recover non-pecuniary loss such as disappointment or distress under Jarvis versus Swan's tour in 1973. Let's conclude. Call's contract is likely frustrated due to the health inspector closure, and he is entitled to recover his deposit under the Law Reform Frustrated Contract Act 1943. However, if the food poisoning resulted from adventure camp negligence, the contract would not be frustrated, and Call could pursue a claim for the breach of contract and damages. In other words, the frustration applies if the closure was outside the adventure camp's control, allowing the call to seek a refund under the Law Reform Frustrated Contract Act 1943. And the second scenario, the no frustration and damages apply if the closure was due to camp's negligence, making the adventure camp liable for breach. Thank you.